Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a book on compulsory purchase, which I think is most important depending on the sort of practice you have. It's called the Law of Compulsory Purchase. It's now actually in its 4th edition from Bloomsbury. The general editor is Richard Honey, Queen's Counsel, and the general editors, in addition to Richard, are James PEREIRA, Queen's Counsel, Rebecca CLUTTEN and Caroline DALY. I think it's probably DALY. I'm not quite sure. I do apologise, Caroline, if I've not pronounced your name properly. Bloomsbury produced some really excellent works. I'm very grateful to them for sending this one to us for review because I was fascinated to see what the law currently is. Elizabeth was the lead writer, and she's given a title for the review, clearly explained, The Law of Compulsory Purchase, now in a new 4th edition, including a guide to new practice directions. And of course the PDs are very important for us as practitioners. Let me have a look at the book first. It's a hardback book, there we go. It's a purple colour. Nothing else, very sort of regal, very royal. The back of the book, let's go to the back first. You see the index. The index is a bit confusing to a certain extent because you've got to look at the part number and then after that you've got a page. So what it has is, for instance, it has B and then 445. So that tells you which part you will find the particular part of the index. I did find that a little bit confusing to start with, and of course it is useful sometimes. It says references are to paragraph numbers. Letters in bold indicate the relevant division. So you've got the page number, but it tells you the division, and you can probably see from the back of the book how it's structured. We'll look at that again in a minute. Let's go to the front of the book. There's the front page, which gives you some idea of what's in it. There's a consultant editor as well, whom I have not mentioned, Guy Roots, Queen's Counsel. Then there's a foreword. Always read the foreword of these books because it does give you an idea of what the current position is concerning the work. The actual foreword is written by Sir Keith Lindblom, Senior President of Tribunals, and it's dated January 2022. Which is useful because it actually gives you some indication of what is changing. The foreword to the previous edition was actually written by Lord Carnwath from the Supreme Court. Then you've got a preface which really sets out what the changes are since the previous edition, and that's written by Richard Honey himself. Then you've got the contents itself, and obviously a large number of chapters all the way through with the various parts. You see that actually they call them divisions, but they're parts. If I'm probably using the wrong words, it says division and so forth, but they're basically individual parts of the book. Running through to division H right at the end, then the index on page 769. So it's under 800 pages, round about that. It's a heavy book though. There's the table of statutes, which are quite substantial here, then the statutory instruments, and then after that you've got the cases. So sometimes it's the cases first, then the statutes and their size, but this time it's the other way around. There are a lot of cases, of course, a lot of work involved. Then after that we get to Division A, or Part A, introduction. Then you've got a sort of mini index for the particular division, setting out the introduction. Then you've got again another little index, lots of indexes in this, there we go. You can see how it's structured. And then you've got a little number there, which is the paragraph numbering, to go with the page numbering, which is actually at the bottom there. Probably see that. It's a slightly different structure from some books you might see, and it sets out the aim and structure of the work in some detail. It's a technical area to a certain extent. Then chapter 2, evolution of the system, and then we run through all the way through. Obviously you've got some bold tables and various other things, and you do have footnotes underneath each of the. So what you've got is you've got a paragraph numbering there, then you will have the footnotes immediately underneath. So you won't find them at the bottom of the book, you'll find them after the actual paragraph numbering. And that may be confusing to some people. You can see again right at the back how it actually works. But once you get into the swing of it, you will find the book is an important, very important work on compulsory purchase. So what do we say about the book? Bearing in mind that Bloomsbury Professional have taken over a lot of titles, and this is one which is an important one for any practitioner in this area. We say this: compulsory purchase. Now there's a term, without doubt, which is likely to send chills down the spine of anyone whose land or property is likely to be affected. It certainly was in my family's case when they compulsory purchased some farming land. So it does cause a lot of concern. Therefore, practitioners advising clients on any aspect of compulsory purchase, particularly redress or remedy, will therefore need this long-established work of reference, which has recently been published by Bloomsbury Professional in their new 4th edition. And if the matter of compensation arises, and there is little doubt that it will, rest assured, for example, that the final 4 divisions of the book's contents, approximately 400 pages, provide specifically detailed advice on virtually every conceivable aspect of compensation, ranging from the right to compensation to finalities such as the hearing, the fees and costs, the appeals, and much more. And that's what you get. Bloomsbury are a very well established, highly competent publisher of legal works, and I'm very grateful to have it. It does make our life a lot easier. Compensation is, of course, only one of the 4 elements adjudged to be intrinsic to the process of compulsory purchase, which the editors have enumerated as powers, authorization, procedures, implementation mechanisms, and finally compensation itself. It sounds daunting, I must say, but once you get into it, you can see how the process actually works. A quick perusal of the book's helpfully detailed table of contents, which tends to be repeated a bit, which is helpful. There are 9 pages of it at the beginning, reveals how extensively and how thoroughly these elements are examined and explained. And I thank the authors very much for that. The 5 divisions of the book from A to E deal with the nature of the system of compulsory purchase, including the powers required to acquire land by agreement as well as by compulsion. And then you've got divisions C and D, for example, explain the procedures for seeking authorization for compulsory purchase and the mechanisms for implementing it. And division E examines the rights to and the assessment of the issues involved in compensation. The book is reliable and it's authoritative, and it deals with an area of law which is all too often fraught with complexity, controversy, and a range of conflicting issues and interests, as well as the case for reform and the frequent difficulties of achieving it. It's controversial, it's emotional, and it's also political, I have to say. Let me give a quote. "The use of powers to acquire land by compulsion," say the editors, "is unsurprisingly the subject of policy debate in the context of housing, urban regeneration and infrastructure." I actually go further. That says politics, putting it bluntly, and it's going to be in the future as we look at the problems concerning housing and the whole view of the government, certainly from the Queen's speech in May 2022 onwards, about where we might be going in this Parliament concerning housing policy. Debatable or not then, compulsory purchase is more often than not a dire necessity for the development of vital new infrastructures and will remain, say the editors, a vital feature in the activities of government, especially in the context of housing and urban regeneration as well as infrastructure. And that will go not just to the smaller developments in terms of scale, but to the very large ones. And of course there are going to be a possible new rights of people concerning planning processes and everything else, but we await that in due course. Of course, this is the point, of course, being made here, is that these activities promote what is called the levelling up of communities in certain parts of the country, while also contributing in many instances to energy regeneration, flood protection and reforestation, as well as a range of other policies aimed at tackling climate change. So you've got a link very much, obviously it's environmental. Remember, planning often comes under environment in local authorities, but it's not just about that. We're looking at the levelling up throughout the whole of the United Kingdom. That's the clear government aim in any event, and obviously that's part of what this book is talking about, although it's dealing specifically with the compulsory purchase of property. Let me conclude by saying clearly this definitive and distinguished work of reference is aimed at providing practitioners in this field with a comprehensive guide to the law and practice relating to compulsory purchase and compensation. It's straightforward, it's logically organised, it's carefully indexed and replete with references to cases and research sources, and it's aimed not only at lawyers but also at surveyors, landowners and anyone, including students and members of the public, involved with any of the issues set out relating to compulsory purchase, and obviously it's a motive subject, as many people will know. Lawyers will regard the new edition, we think, of this book as an essential addition to any well-stocked library. Now, the date of publication of the hardback 4th edition is cited at the 1st of March 2022. Let's have a look at the book again. There it is. It's, as I say, an important book. The 4th edition, obviously, with the foreword, is well worth having a good look at because of where they're going with the book at the moment for 2022 and beyond. Clearly what we have at the moment with the book is, the preface covers it very well, is looking at where the history of compulsory purchase comes in and where we're actually going at the moment, because it first appeared as a book in the year 2000 and 22 years later we're already on to a 4th edition.